This is Barry Zelma speaking for Claim School Incorporated's blog, Zelma on Insurance. Today we're going to explain why an insurer is immune from a malicious prosecution suit if its SIU reports to the state in good faith a potential fraudulent claim that results in an arrest, trial, and acquittal, thereby allowing or causing the acquitted to sue for malicious prosecution. It was a case where prior damage was added to a minor accident and drew the suspected fraudulent claim report to the state of Florida. In a case entitled Hanover Insurance Group v. Luke Frazier, the Florida Court of Appeals on April 3, 2024, dealt with a suit by Frazier against Hanover and Michael Arline, Jr., an employee of Hanover's Special Investigation Unit for malicious prosecution, after Frazier was acquitted of charges of making a false statement in support of an insurance claim and grand theft arising from statements Frazier made to Hanover in connection with an insurance claim. Hanover and Arline defended, claiming immunity from suit under Section 626.989 (4) of Florida statutes. The trial court rejected the claims of immunity and ultimately entered judgment in favor of Frazier. Hanover and Arline, of course, appealed. Every insurer admitted to do business in Florida is statutorily required to establish and maintain an anti-fraud investigation unit or division, commonly called a Special Investigations Unit or an SIU, to investigate and report possible fraudulent insurance acts by insureds or by persons making claims against policies held by insureds. If an insurer has knowledge or believes that a fraudulent insurance act has been committed, it must send a report to the Division of Investigative and Forensic Services detailing the information it has giving rise to its suspicion. This reporting is mandatory by statute, and upon receiving a report, the DIFS conducts an independent investigation. And should DIFS's investigation lead to conclude that there has been a violation of law, it is required by statute to report it to the state attorney. As part of this legislatively mandated anti-fraud program, the statute provides insurers and their employees immunity from civil actions absent fraud or bad faith arising out of the furnishing of the information required by the statute. Arline, as an SIU investigator, investigated a dispute that arose after Frazier was involved in a minor collision while driving a car owned by a Hanover-insured Marvick Grant. The driver of the other car involved in the collision, Wendy Williams, filed a claim with Hanover. Williams's claim was unresolved for almost a month while Hanover tried unsuccessfully to get a statement from Grant and Frazier. When the adjuster finally spoke to Frazier, his description of the collision and the resulting damage was different than the amount Williams had provided. Frazier told Hanover that as the cars approached the toll plaza, Williams accelerated to get in front of him, and the rear passenger side of her car hit the front driver's side of his car, which then pushed his car into the yellow post near the toll booth, causing damage to the passenger side of his car, not just the driver's side. Relying on Frazier's statement, Hanover's adjuster told Williams that he was holding her 50% responsible for the accident and that Hanover would compensate her accordingly. Williams told the adjuster this was unacceptable and that she intended to contact her carrier and retain an attorney. Unbeknownst to Williams, at the time this took place, Grant had filed a claim with Hanover for damage to her car, which included damage to the passenger side of the car. Williams first learned of Grant's claim when she got a subrogation letter from Hanover stating it was holding her responsible for nearly $5,000 in damages to Grant's car. Williams was stunned at the amount because the damage to Grant's car, as well as hers, had been minor. Williams advised Hanover her belief that Frazier and Grant were acting fraudulently because they were claiming that both sides of Grant's car were damaged in the collision with her car. Hanover assigned Arline to investigate the conflicting accounts given by Frazier and Williams filed a fraud report with DIFS, alleging that Frazier and Grant were claiming damages to Grant's car that were not related to the accident in which she was involved. Based on Williams's allegations, DIFS opened an investigation before even hearing from Hanover. Arline later completed his investigation and concluded Grant should have filed 2 claims with Hanover, not 1, and being subject to 2 deductibles. DIFS determined that there was probable cause to believe that Grant and Frazier made material misrepresentations of fact in their claim, and with Hanover in that they claimed Grant's car was damaged on the passenger side during the accident when it was not. Frazier and Grant were charged with making a false statement to an insurance company and grand theft. After a jury found Frazier not guilty, he sued for malicious prosecution against Hanover and Arline. He didn't sue for malicious prosecution against Williams. Absent fraud or bad faith, the Court of Appeal concluded, the statute immunizes insurers and their employees if they have done what is required by the anti-fraud statute. Frazier's evidence entirely failed to show fraud or bad faith in connection with Arline's investigation or report to DIFS. Accordingly, Arline and Hanover were statutorily immune from suit, and the judgment in favor of Frazier was reversed. In my opinion, states like Florida and my own state of California realize that insurance fraud makes it difficult or impossible for your insurers in the state to make a profit and provide affordable insurance to its citizens. By requiring insurers to maintain an SIU and report all suspected insurance fraud to the DIFS, it hopes to reduce the impact of insurance fraud. Acting on the report of Ms. Williams and Hanover's SIU, Frazier was arrested for fraud, tried, and fortunately for him, he was acquitted. Since Hanover and its SIU reported the potential fraud in good faith, it was immune from suit, and the judgment in favor of Williams was reversed, and the intent of the statute was enforced. This should make it clear to any insurer involved in a state that has a similar Insurance Frauds Prevention Act that allows for such immunity to encourage them to report suspected fraudulent claims and thereby reduce the potential for insurance fraud and reduce the exceeding expense incurred by insurers to pay to fraudsters. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will receive notice of every blog posting, usually 5 or 6 a week, and access to the more than 4,750 blog postings. You can also subscribe to the videos on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further information and detail about insurance, insurance law, insurance fraud, and insurance claims, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.